Negovan of Gricing Law. Welcome to our vlog. Today we're going to talk about going public, arbitration, and sexual harassment claims. Employer-employee arbitration provisions are ubiquitous. They're used all the time. Employers like them because going to arbitration is quicker. It's cheaper. It's private. Employees may sign an arbitration provision in an employment agreement and not even know it's there. Even if they know it's there, they may not understand what it means. So let's talk about what's happening right now. In December of 2017, there was a bill introduced to the Senate to actually prohibit arbitration provisions in employment agreements that capture sexual harassment claims. So if an employer has a sexual harassment claim brought against it, and there's an arbitration provision in the employment agreement, this bill, if it becomes a law, would prohibit enforcement of that arbitration agreement, and the employer would have to go to court with the employee. This is a big change. This is big. Arbitration agreements in the U.S. are highly favored. Courts have been enforcing them for decades. The Supreme Court, in fact, in our earlier blog, we talked about a case where the Supreme Court said, even if a state court believes that there are specific state court reasons why an arbitration provision should not be enforced, the Federal Arbitration Act overrides that. So on a federal level, arbitration agreements are almost always enforced. This bill is going to rock the world of employers if it gets passed. So let's talk about some of the things you can and cannot do if you're going to put an arbitration provision in an employment agreement. One is you cannot make up the rules of the arbitration if you're the employer. So there's a case called Hooters. Of course, it would be Hooters. In 2010, they had a case where Ms. Phillips brought a sexual harassment claim against Hooters, and the arbitration provision in the employment agreement was sought to be enforced by Hooters. The court said, no way. The agreement included such onerous arbitration rules. Only Hooters could decide whether a summary judgment motion would be brought. Only Hooters would be able to introduce hearsay evidence. It had so many very employer-friendly provisions in the rules themselves. The court said that cannot be enforced. It's a sham of an arbitration. So don't do that. Just put in your arbitration provision in your employment agreement that the Federal Arbitration Act applies. AAA rules for employment may apply, or you can use some other commercially accepted arbitration provisions. If you are not going to use an arbitration provision in your employment agreement, then you could put in some choice of law, forum selection type of provisions in the employment agreement that may be more friendly. But why is this such a problem right now? Arbitration agreements have been enforced forever. The issue is coming to the forefront with the Me Too movement. And women are starting to say, and all people of all sexes, both sexes or all sexes, are trying to say, well, if you go to arbitration, it's really covering up the problem. It's a private proceeding. The rulings are not published. You can't really find them in the public blogosphere or anywhere. So it's just an old boys network, and it's exacerbating the problem and keeping it covered up. There's a lot of commentators that agree with this, that say that courts are really the only place that you can get justice. So there's a debate, right? Arbitration, you can pick the arbitrator. The arbitrator has specific education and experience in employment and discrimination laws that go to the heart of the exact issue that you're trying to get decided. Judges, on the other hand, are generalists. They will hear a criminal case one day, maybe a divorce case the next day, and perhaps a discrimination case the third day, and they have to know all of that. Arbitrators are also not bound by the rules of evidence, so they can recall witnesses, they can ask questions, they can hear hearsay evidence, they can go to visit the workplace. They can ask for witnesses to be brought into them. These are things that a trial court would never be able to do. Trial courts are very limited in their proceedings, in the types of evidence that they will allow to be brought into the courtroom, and the types of activities that are considered in deciding whether discrimination has occurred or not. So it's really a societal issue. Do we want to arbitrate these types of claims, or do we believe that they are more likely to affect societal change if they're heard in the public? We'll have to see what happens in Congress and the Senate regarding the bill. Thank you for watching. You can visit me at www.gricinglaw.com and watch again.